about that. So there are 2 firearms, 2 handguns.
Well, Your Honor,
that she testified about.
Yes, Your Honor.
well, Your Honor, the problem I think is I, which is a broad category.
Right. So
I have a problem with her testifying about Aaron Hernandez's possession of guns.
And again, I'm limiting it, as I just indicated, to those 2 areas of not rifle, car, rifle in
and the ones
home,
that she has testified she saw.
that she has testified. But again, Your Honor, I would just say this.
No, I'm just saying her recollection at the grand jury.
Yes, but if I say to her, did you ever see any firearms, handguns in the home?
Right.
And if she previously hadn't disclosed to us about the little silver handgun.
Which is what she talked about in Boston.
No, she didn't, because it's totally different.
Okay,
the size of it is different.
We'll deal with that too.
But I guess what I'm suggesting, the idea that all of a sudden I couldn't ask her the question. She's an immunized witness. Any witness who's in that chair, I can ask the question. It's a fair question. Have you ever seen firearms? If she didn't tell us about another firearm, this is her opportunity to do it. And the defense's suggestion, I shouldn't be allowed to ask that question. I just don't even understand that.
Defense is suggesting that under cases like Commonwealth versus Hart, you should not be asking a question where there's no good faith basis to believe that she's going to say anything other than no or I don't recall. I understand that time has passed, but because of the prejudice of having questions asked to which the answer is no, I don't recall, we will check whether her recollection is any differently. Certainly, I am going to, you certainly can inquire of her with respect to those she saw, but to the extent she has said she did not see something else prior to at that time, I will have that can be inquired, and then that really I and J are really connected. I'm not going to exclude all evidence of her possession, her knowledge of possession of guns.
Well, Your Honor, respectfully, if again, as our argument is that they said what she said on that subject is a lie. If they're trying to elicit whatever she said before for its truth, that's improper. If they're trying to elicit the same testimony to show that she's a liar, that's improper. And therefore, the only basis for proceeding on that subject matter for which they indicted her for perjury is if she's prepared to say something different. And the only way to know that, since there's nothing in discovery suggesting that she's going to say something different, is with a voir dire. And that's why she should have a voir dire.
Right, that's a separate issue.
Yes, sir.
But I don't see the Commonwealth, when it charged in the Bill of Particulars concerning possession of guns, was, and given the arguments made in that case, that the Commonwealth has ever claimed that to the extent she said she saw a gun, that testimony was perjurious, as opposed to the vagueness of their Bill of Particulars. The court is not holding against the Commonwealth to the extent that from the vagueness of the Bill of Particulars does not mean that the Commonwealth has actual knowledge today or should know today that her testimony regarding seeing the gun is false. Indeed, the nature of her testimony has in some way been corroborated by other testimony in the case. So I do not find that at this point the Commonwealth to elicit testimony as to what she said she saw, that the Commonwealth would be knowingly or recklessly introducing a perjured testimony.
I think they should be held to the vagueness of the Bill of Particulars. That's the Bill of Particulars. That's all we have to go by. I can't interpret what they really mean. All we can say is this is what they claim she lied about, and they shouldn't be allowed to replow that ground unless they have a good faith basis to believe she's going to say something different.
Your Honor, if I could just respond. One, to suggest we don't have a good faith basis to ask the question. This is a woman who's been involved in all kinds of things at the direction of the defendant. And so when she comes in and there's affirmative evidence of her lying at the grand jury, and now they're saying, oh no, you're stuck with that. And so therefore when we immunize her and just say no, it's our hope that when she comes in a first-degree murder case, knowing that she's been immunized, knowing what the penalties for failure to tell the truth, that we can't now ask her a question. So if, in fact, it was either false, if it was misleading, or if it was incomplete, that she now understands she has to answer it truthfully. And what they're trying to suggest, oh, no, 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 you're stuck with the lie or the misleading or the incomplete, and you can't then ask any other question. I find that just to be ridiculous.
Thank you.
So,
K, conversation with Mr. Hernandez about seeing a gun in the house. Again, to the extent she said she is going to say anything differently or said anything afterwards. No idea of the time frame when she saw a gun in the drawer, other than it was obviously after they moved into the house. Again, if she, I'll let you ask that on a voir dire to see if she has a different memory today. The multiple conversations about Aaron Hernandez, to the extent she has a greater memory today, she certainly can testify. Concerning conversations with Mr. Hernandez when he called her about removing items, it would appear from the Commonwealth's responses in the other case that what the Commonwealth claims is a lie is her not giving further specifics. I mean, she does testify as to what she says Mr. Hernandez said to her in terms of removal and the importance of it, et cetera, et cetera. I don't...
Right. Again, just to ask you the question, what, and this is how I would intend to do it, Your Honor.
What did
in front
he
of the
say?
jury or voir dire or whatever. Just, right, you get the phone call. Tell us about that conversation.
Right.
And to the extent that...
There's no need to do it. That is certainly allowed. I don't read the... I don't read N as precluding that the Commonwealth is not saying that everything she said, that what she said was false. And you certainly can use, to the extent you wish, the bill of particulars that was filed in the case in terms of your cross-examination, if there's anything you wanted to do as to her knowledge. But I don't see the Commonwealth as saying everything she said was false, as opposed to omissions. Her lack of knowledge of the items, that, while the Commonwealth claims that was false, her lack of knowledge, it seems to me that that's relevant, and I would allow that with respect, because the fact that they asked her is relevant. The jury would expect the Commonwealth would be trying to know what was in the box and would be asking that question and would take follow-up steps depending on the answer to that question and also the question with respect to where she disposed of the items.
But then, Your Honor, they indicted her for perjury for saying she didn't know what was in the box.
It's just that was her answer.
Right.
Is not coming in for the truth, but it's relevant to me, to the thoroughness of the government's investigation, that they, when they had a chance to speak to her, they asked her that, and that was her response. Because had she said, I disposed of it in a dumpster on the corner of X and Y, then you would have expected the police to go to that dumpster, retrieve it, or attempt to retrieve it. And it would be, given the issues that have been raised with respect to the quality of the government's investigation, I don't think it's fair to leave the jury with an inference that when they had her before a grand jury, they didn't even ask her, did you know what's in the box? And they didn't even ask her where she disposed of them.
Well, Your Honor, I understand that argument.
So it's not coming in for the truth, and the jury would be indicated that it's not coming in for the truth, that she doesn't recall.
Well, I understand that, Your Honor, but frankly, on that, using that line of reasoning, I suppose they could argue that every question they ask in the grand jury.
I don't think most of them don't fall into that category.
Just when you say it's not coming for the truth, there's evidence in her own description about what she did and what information the jury could find about what she did know. She denied taking covert action to sneak that bag with the box out of the house. She then put items, children's clothing, that was on top of it and carried it out in that manner, acknowledging that there was no reason to do that. It made it more burdensome. And then borrowing the car, she said, oh, I borrowed the car in the past. The sister refuted that. Then the manner in which she went out, all of that is for the truth. In fact, that's why we're calling her as a witness, to give us all the details, and every witness who takes the box is then assessed, their credibility is assessed by all the facts and circumstances.
But I think the defense is pointing to the bill of particulars that says she committed perjury when she talked about the manner in which she removed it, how she removed it, where she went, and where and when and how she disposed of the items, the very things that you're now saying you are putting in for the truth, that she said she put it in a bag, she put it in the car, she drove around, she put it in a dumpster.
The fact that there were partial answers, I guess I'm suggesting, doesn't mean she shouldn't be asked. Let's assume she didn't give the 100% truth at that time. She gave us 50%.
I agree, and I think Commonwealth cannot be fairly read as saying that everything she affirmatively testified is true, is false. I think Commonwealth can ask what she did with the items and where she went with the items. That she did not speak with others about removing the items from the home. Again, that would why would that be admissible, whether or not she spoke to someone else? Why wouldn't that be hearsay?
She would just be asked, did she have any conversation about...
Right, but why wouldn't that be hearsay unless it's with Mr. Hernandez, what she said out of court?
Because if it was with Mr. Wallace, Mr. Ortiz, Ms. Singleton, other people who were involved in the conspiracy, Your Honor. So again, just to be able to ask her the question, did you speak to anyone else about those items? They disappear.
Right. I will...
Your Honor, I think the court, given the court's ruling yesterday, that will be limited to the period of time before Mr. Wallace and Mr. Ortiz were incarcerated in June.
And Ms. Singleton in August.
And that getting rid of the box was not important to her. Why is her
that goes to
mental
her
status.
Credibility about what she knew and whether she was being truthful, Your Honor. Again, she's being presented as a witness.
Your Honor, presenting her as a witness to impeach her credibility, and that's improper.
No, to get to the truth, having her under oath, her understanding she's been immunized, her understanding the repercussions of giving false testimony is an effort, good faith effort, by us to get to the truth.
I'll do a voir dire of her, which should be very, very limited. After her name, jumping to E. Conversation up to the time of the grand jury about whether the police had come to her home or why he went, just to see whether her recollection today is any different, to the extent so that I can then rule as to whether those questions are simply being asked to elicit no's or I don't know. So the witness may come into the court.
Strike this way, please. Just follow me. Face the magistrate and raise your right hand, please.
Man, do you solemnly swear that the testimony you're about to give to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, please.
Good morning, ma'am.
Good morning.
Would you state your full name, please?
Sure, it's Cheyenne Jenkins.
And could you spell your first name?
Sure, it's Shayannana.
And I'm just going to ask you if you maybe pull that microphone a little closer to you.
This one
just
here?
so everyone can hear you.
Okay.
Okay. Could you spell your last name, please?
Sure, it's Jenkins.
Okay. And how old are you?
I'm 25.
Now, ma'am, I'm just going to take you back to June of 2013. At that time, were you living at 22 Ronald C. Meyer?
Why don't we just jump to
Okay.
the first one, which is E, conversations about why the police came to the house.
Okay. Ma'am, at some point, there was an investigation into the matter of the death of Odin Lloyd. Is that right?
Yes.
And do you recall on June 17th, in the evening hours of June 17, 2013, the police had come to your home?
Yes.
And at some point, did you have any conversation with Aaron Hernandez about the police coming to the home?
Well, it was after I saw flashlights. So, I mean, we didn't necessarily know who was at our front door.
Okay, well, let me just ask you this. At some point, were you, Mr. Hernandez, and your child in your bedroom?
Yes.
And was it approximately 9:45 in the evening?
I don't remember the time, but it was in the evening.
Do you remember it being dark?
Yes.
Okay. And was your attention drawn to your windows, seeing some flashlights going by your windows?
Yes.
And at that time, did you get out of bed and go over and look at a surveillance monitor?
Yes.
And were you able to see...
I mean, there was a lot of testimony in this in which the witness gave responses, and none of those were claimed to be false in the bill of particulars. So this is a very limited question on, I think, 252 maybe, and 254, which was, this is a limited question, which is, was there a conversation about why the police came or why he went to the police station? There's been, so all of the other that preceded it with respect to conversations are not at issue here.
Oh, that's fine. Thank you, Your Honor. So, ma'am, just, did you have a conversation with Mr. Hernandez about why the police had come to your home?
Yes.
Okay. When did you have that conversation?
I think before we went down to the police station.
Okay. And just tell us about what was said about why they had come to your home.
I just asked what was going on. He said he didn't know.
Okay. Was there any further conversation at that time?
No.
Okay. And at some point after that, within approximately an hour and 15 minutes, you recall going to actually driving Mr. Hernandez and yourself and your child to the police station.
Yes.
And did you have a conversation with him at any time since the first occasion you saw the police at the house to the time you got to the police station about why he was going to the police station?
No. No. We both had question marks, so no, we didn't have any further conversation, just, general as far as packing the baby up and getting in the car to go.
Okay, so there was no further conversation about what do you think this is about or anything of that nature?
No.
Okay. So other than that first question that you asked him, that was back at the house, about what's this about, and he indicated he didn't know.
Right.
Is there anything else, ma'am, other than that?
No.
Okay. Thank you, Your Honor.
And then you can turn to F.
And,
So on that one, Your Honor, I believe that's completely consistent with what you said before the grand jury, and I would ask that...
excuse me. May I continue, Your Honor? Now, at some point, was there any other conversation about Odin Lloyd's murder with the defendant, with Aaron Hernandez?
Yes.
Okay.
And this is up to the time of your grand jury testimony you're being asked.
Okay.
Up to the time of your grand jury testimony, did you have any further conversation about...
Or any conversation?
Any conversation at all about Odin Lloyd investigation of the homicide?
Yes.
Okay, and just tell us about that.
I believe it's when Aaron got home from the police station. when I had found out that Odin was murdered, I asked him if he did it. He said no, and that was the extent of our conversation.
And did you have any conversation with him about whether he had been with Odin Lloyd on the night of murder?
Not that I could remember.
And what about any conversation about when, at some point you learned the body was found near your home?
Yes.
Did you have a conversation with him about that?
I don't believe so.
And, Your Honor, just with regard to, have you had any conversation since those times? So up to the grand jury?
Well, since the grand jury, you may ask.
Oh, fair enough. No, that was E and F.
H.
And H. Do you recall having any conversation that about, there was a text message that you had received from Aaron Hernandez, and this is the one about a black box? Remember that?
I remember a text message, yes, but I don't remember specifically it saying a black box.
Okay. But there was something about a black box behind the movie screen, and then about the TV. Remember what happened to the TV?
Yes, I remember the conversation.
Okay.
Yes.
Now, did you have a conversation with, outside of, after receiving the text, at some point, did you have a conversation
We
with?
may ask about any conversation. This issue is only whether she understood the text.
Is that it?
Well, you may ask her whether she understood the
Oh, I thought you meant in front of the jury.
No, you may
Later.
ask, you were asking now about conversations. That's not an issue. This is just whether she understood the text.
Yes. Did you understand that text, ma'am?
I did not.
Okay. And to the extent, was there any portion of that text message that you understood?
I understood when he asked, I guess when he indicated what I had done with the other TV. And I understood that part, but I didn't understand the rest.
Okay.
Number of guns?
And ma'am, with regard to the number of guns in the home, how many guns have you seen in your home? Again, I'm talking about firearms, handguns.
One.
Okay. And that gun, where did you see that?
In our junk drawer,
Okay, and where's the junk drawer?
in the kitchen.
Do you recall any other occasion seeing any other guns in the home?
No.
With respect to any conversation about the gun?
Yes, did you have any conversations with Mr. Hernandez about the gun that you saw?
I don't remember any specific conversations. I remember giving him a look and kind of that being like that indicating him to remove it, but I don't remember if we exchanged words in regards to the gun.
And since that time, no conversation about that gun?
No.
Okay.
The time frame?
This is L, Your Honor.
Yes.
With regard to that, the time frame of when you observed that gun in the junk drawer of your home, when do you recall that occurring?
I don't remember.
Okay. And you do recall that occurred at 22 Ronald C. Meyer?
Correct.
Okay. Is that M, Your Honor?
Sure.
With regard to when you called to the grand jury, you were asked a number of questions, is that right?
That's correct.
And there were certain questions you indicated that you had no memory of?
That's correct.
To the extent, have you reviewed your grand jury, your prior grand jury testimony?
I have.
And as to any of those questions, has your memory been revived?
In a sense,
Okay.
yes.
And with regard to what questions, if you know?
I believe there was a specific question where you indicated if I had, I don't remember the exact words, but it was along the lines of me having interactions with Bo, and it was an honest mistake, and I didn't really understand the question, and my answer has changed since then.
And
Outside-
with respect to conversations with Mr. Hernandez, is your answer any differently than it was in the grand jury?
No.
Where you said you did not remember certain things.
Right, no.
And
Your Honor,
and you may ask, because,
Sort of lost here, Your Honor. Which are we on now?
Q.
Ma'am, there were certain items you recall that you removed from the home,
Yes.
and who have you spoken to about removal of those items?
Who have I spoken to?
Yes.
Like currently? About,
No,
or,
just going back.
I'm sorry, I don't understand.
Part of the
what-
grand jury.
Okay. Who I was instructed to take it out of the home, if that's what if I'm understanding the question correctly.
After that time, did you talk to anybody at all about removing items?
No,
So outside of the defendant, you didn't speak to anybody else?
no.
T.
And ma'am, you were asked certain questions about your reason for getting rid of the box,
Right.
and you were asked whether there were certain steps you would taken to make sure it was, that it essentially disappeared. Is that true?
Yes.
And you were asked whether that was important, as a result of the phone call from the defendant, whether that was important for you to do that.
I believe the questions in the grand jury were, was it important to her? Was it a concern of hers? And whether it was important to her, not, I think there was testimony with respect to what Mr. Hernandez had said to her with respect to importance.
Yes, Your Honor, there are two parts to this. That the defendant had called you and said it was important that you go down and get this box and get rid of it. Is that right?
I believe so.
And you say you believe so. Is there any uncertainty about that?
I'm not too sure because
You'll be able to refresh your recollection with the grand jury testimony.
And then you were asked a question whether it was then important to you to get rid of that item.
Right.
Okay, and was that?
Yes.
Continue, U, B.
I'm sorry, number you?
U and B.
U and B. Now, you were also asked whether you had taken certain steps to cover or conceal or hide the box when you removed it from the home.
Yes.
And do you recall doing that?
Yes.
And you were asked whether you had told anyone about disposing of the box, that you had not told anyone about disposing of the box because it was not important to you in that, and not because you sought to conceal your actions. In fact, when you took that box out and concealed it, were you attempting to do that in a way so people didn't know what you were doing?
That's correct.
And, I'm sorry, you're on the next.
V is really encompassed with, well, you may have, this is whether you told anyone or why you didn't tell anyone.
And
Do V.
did you tell anybody about what you were doing
In regards to what?
to taking rid of getting rid of the box?
No.
W.
And you were asked about a white sweatshirt that had belonged to Mr. Hernandez, and you were asked if you know what had happened to that. So,
I believe so, yes.
and you recall indicating there was some form of shirt that you had washed that morning at his request?
Yes.
And did you know what had happened to the white sweatshirt that you were being asked about relating to a shirt that he had worn the night before?
I do not.
X.
And you were, I asked you, I think at that time, whether you had previously borrowed your sister's car.
Right.
And you said it wasn't uncommon.
Right.
Okay. Is that, having had an opportunity to reflect on, I think at the time you were asked, or when was the last time you couldn't remember, is that true?
Right.
And was it uncommon for you to use your sister's car?
Now, actually looking back at my testimony, I wasn't sure if it was my sister's car or my mother's car that I had borrowed frequently.
So the question about your sister's car, would you agree it was uncommon for you to use her car?
I really can't say because I think that I have before, but I can't remember a specific time.
Okay. The question, okay, that you were asked whether it was uncommon, or what, so therefore it was uncommon.
Yeah, I would say it's uncommon.
Okay.
Why?
And did you know Bo's name before the murder, his true name, before the murder of Odin Lloyd?
No.
You can skip C.
And then you were asked questions about whether, since the homicide of Odin Lloyd, you had spoken to...
You can skip C. She's indicated her testimony would be different.
Yes, okay, fair enough, Your Honor.
AA.
AA is, again, you didn't, at any later point prior to the grand jury, that you didn't know Bo's true name.
That's correct. I didn't know his true name.
And BB, concerning a confidentiality agreement, were there certain conversations you had about signing a confidentiality agreement with either the babysitter or the housekeepers?
Yes.
And some of those conversations...
This is just house cleaners.
And with regard to the house cleaners, those conversations occur after the homicide of some of those conversations occur after the homicide of Odin Lloyd?
I believe so, yes.
And was that in the presence of the defendant?
No.
Do you recall ever, at his instruction, providing confidentiality agreements after the homicide of Odin Lloyd to
No.
any of the housekeepers?
No, it's something that I did by myself.
Okay. And do you know whether he was present at that time?
No.
No, meaning he was not?
Not with, I mean, I don't know him being in the house, I'm not sure, but as far as the conversation, you know, Grazi and I, no.
How about with anyone else? Do you recall having a different, not with Grazi, but with Marahelia?
I'm sorry?
Marahelia Prinholero? Remember having a conversation with her?
Honestly, the only one I dealt with was Grazi.
Okay. So that you would have no memory then of having such an interaction, giving her certain documents?
I believe I gave one of the ladies documents. I couldn't tell you her name. Grazi wasn't there that day.
Okay. And then CC, you were asked questions about where you went after dropping off Aaron Hernandez at the North Attleboro Police Station. Is that true?
Yes.
And you recall indicating or suggesting that you had gone to your home.
Yes.
And in fact, did you go somewhere other than your home?
Yes.
Thank you. You may sit down. We'll bring you back in a few minutes.
Okay.
I've read the briefs. I've heard the argument. Anyone else want to say anything?
Nothing further on?
No, Your Honor.
A through D, the Commonwealth does not intend to inquire E, she has said now that he said he did not know and I will allow that in. So I will allow the question about any conversation, Mr. Hernandez, about why the police had come to the home, not with respect to why he went to the police station. To F, up to the time of the grand jury, there is no testimony that she recalls any conversation other than the denial, and I will not allow that evidence of a denial, and there's no good faith basis to believe that she is, to simply put her on to say something that the Commonwealth believes is untruthful, I will not permit. G, the Commonwealth is not intending to inquire. H, she certainly can testify as to what, about the television and her destroying a previous television and her understanding of any portion of the message. With respect to guns, she may be asked about the gun she saw in the home, but not asked follow-up questions about other guns, since her answer is consistent with her grand jury testimony that the Commonwealth says is false.
Just so it's clear, when the questioning begins, there was the second statement that she, with regard to the description of...
Right, you can certainly get the entire description of the gun and where it was.
But there was then a second one, which is she indicates it's at the same spot but describes it totally different. Just so that I'd be...
Which would be consistent with the 22?
Well,
if it's not a gun, is it consistent with a gun that could have been...
She describes it 6 or 7 inches long, whereas the first one she described black at 10 inches long. This one 6 or 7, and she describes it as silver. And again, that would be consistent with testimony that would be coming from a different gun that was observed in the lockbox.
But that's coming in for a very limited purpose, that there was that he used the lockbox as a place to store guns.
I understand, Your Honor.
So I will limit her testimony, therefore, to the guns that can be used as part of the joint venture, either by being carried that night, such as the 22, or by being the actual murder weapon.
Well, and so just so I understand perfectly, that this second that she would, I would just ask her, did she later give a description of a gun that was different than the first one?
Right, I would exclude that under the early motions in limine, which is the only guns the court is permitting into evidence are the 22, the 45, and the observation of a lockbox being used for a weapon.
Right, but there were 3. It's the Commonwealth's theory. There are 3 individuals, Your Honor, and there's 3 separate, by description, guns in the home. This would be consistent with the gun seen in the lockbox, which is not the silver and black small one. This is a different gun that she's now describing, also in the home, in 6 or 7 inches in this area of the junk drawer. So I think, in fairness, we should be able to at least point that out, that there is a second gun, and again, that would be 3 guns, different types of guns that are observed in the home.
Well, we disagree, Your Honor. I mean, the court has made it quite clear that there's evidence about 2 guns that's been allowed in this case, the 22 and the 45, and I don't see anything in this grand jury testimony about another gun, and if they want to just try to impeach her, that's exactly what they shouldn't be allowed to do.
Well, but I don't think they're using that for impeachment. I think they're saying she will give affirmative testimony with respect to a...
Well, then we should have another voir dire, and let's find out if that in fact is the case. Because I didn't hear any voir dire about that.
The court is excluding that evidence. At no point, when we've done all the motions in limine, the reason other weapons were excluded under the theory that anyone could have carried an additional weapon, and that was not made with respect to the the court will limit it to the extent it is other than the 22 or 45.
And Your Honor, just for the clarification, we've always been proponents of that gun in the lockbox being different.
Oh, yes. And I will
Right.
allow that testimony when Mr. Bradley testifies as to him
But
seeing
this
the
is
gun in the
corroborative evidence
lockbox.
of another witness who's in the home, who the jury could find, because I suspect there'll be some vigorous cross-examination of Mr. Bradley. This is his girlfriend, who's going to describe a gun that would be consistent with what Mr. Bradley would say. So in some ways, it'd be an unfairness to put Mr. Bradley out there to be vigorously cross-examined that he's making this up for whatever reason, when in fact we have a witness who also describes a similar type of gun. And in fact, that witness, Ms. Jenkins, is the one who goes down and recovers that box.
Your Honor, she just said on voir dire she'd only seen one gun in the home. That's what she said before the grand jury. That's what she was indicted for perjury for. And I mean, she said it again today. They should not be allowed to elicit that and then impeach her. That's improper, and they shouldn't be allowed to do it.
Well, I don't see that as impeachment. I think it's to the extent they want to show her a grand jury testimony or wherever she has testified about this other gun, she may. I will admit it with respect to, because I do think for the last argument made by the Commonwealth as corroboration.
Well, Your Honor, what would it be other than impeachment? I mean, that she's not saying...
It's not
she doesn't
impeachment.
remember.
It's if she's firmly saying she sees a gun, and Mr. Bradley is going to testify he saw that same gun, and Mr. Bradley may be impeached for credibility, may be significantly questioned. This is corroboration that Mr. Bradley is not just coming in and making up a third gun. With respect to conversations, her testimony has been the same, and I will not permit the Commonwealth to elicit that testimony, which it believes to be perjurious, and same on L, same on M. She may testify with respect to the conversations with Mr. Hernandez on June 18, as she testified at length before the grand jury with respect to those. I will allow O to be asked with respect to her knowledge. I will allow the questions to be asked as to how procedure she did in terms of removal. I will not allow Q since it is consistent and with what she testified before the grand jury. At least with respect to up to the time of the grand jury. It's consistent, and the Commonwealth says it's false. They may inquire with respect to R and S. Her testimony today on T is different, so they can inquire with respect to that. Her testimony today on U is different. They can inquire on that. V, not. Again, that's really, that she didn't speak with others is the same as Q. That she didn't know what happened to a white sweatshirt again, I will not permit it since it's consistent and the Commonwealth says her testimony is false. They may inquire with respect to X, which she now has testifies somewhat differently. Not inquire as to Y or AA, both of which are no's that the Commonwealth believes are false. They may inquire as to Z, where she has testified it's differently. They may inquire as to CC, where she has said it's differently. I don't believe the Commonwealth is going to be asking about immigration issues, is it?
No, Your Honor.
And the testimony on the confidentiality agreement was that she was certain that it was prior to it all happening. She doesn't testify differently today. Or actually, well, actually, I think today she's.
I believe she said it was.
Yeah, I think today she does say afterwards, so you may inquire with respect to that. There were a couple of other things. As I indicated, the denial, unless the defense is not objecting to this, to her conversation of denial, where he indicates.
We have no problem with them eliciting that, Your Honor.
Well, wants to elicit denial, evidence it may. This is no objection by the defense. There were also a couple of references to talking to his lawyers.
We don't intend to get into that, Your Honor.
So she should be instructed by her counsel. Is her counsel in the courtroom? Yes. She should be instructed that when she's asked, for example, there was a delay between when the door was opened and when the police were, there was a delay between when the door was opened for the police and when the police were first observed. She was asked before the grand jury as to...
Her counsel's here, Your Honor.
Right, that's fine. She was asked before the grand jury as to what Mr. Hernandez was doing during that delay period, and her response was he was speaking to his lawyers, he was calling his lawyers. She may be asked about that delay, and she certainly can testify he made a phone call, but she should be instructed not to refer that it was specifically with his lawyers. And similarly, the conversation that allegedly occurred that she testified to with respect to what Mr. Hernandez said about disposing of a box. She testified that it was while he was at the offices of Ropes and Gray. She certainly will be asked to and may testify as to the full extent of that conversation and as to what Mr. Hernandez said to her, and that she knew it was Mr. Hernandez, and she may be asked whether she recognized the phone number, the phone as Mr. Hernandez's phone, but it shouldn't be, she should not indicate.
Your Honor, I'm not. Your Honor.
Unless the defense wants that he was talking to his lawyers or that it was from Ropes and Gray, but since given some of the other arguments made by the defense on other matters, I wanted to make sure that that was not, that we didn't have to deal with that in the middle of her testimony.
Yes, Your Honor. Your Honor, with respect to that first, to the call that he made when the police were at the house, we will elicit, if the Commonwealth doesn't, that he was calling his lawyers.
Okay, so there's no objection then to her?
Yes.
Okay, so then with respect to that one,
yes, Your Honor,
there should be no, she doesn't need to be advised about anything with respect to that conversation.
As far as the next day...
With respect to the next day, that the phone call was from Ropes and Gray, is there an objection to that?
Yes, Your Honor. That's irrelevant.
Two things. The first one is his calls...
It doesn't matter anymore, there's no objection. So.
Well, there is from our point of view, because one, he's not calling the lawyers, he's calling Ernest Wallace. And so, and for them to suggest, because that's not for some time later, so, and I don't know that how she would be able to testify that he's calling his lawyers. So we would